My name is Renee Castillo de la Cruz, and I'm a staff attorney at the Texas Children's. On behalf of the Commission, I would like to welcome you today to our webinar entitled Trial Skills for Child Welfare Cases, Preserving Your Record for Appeal. This presentation is provided by Leslie Capace, Managing Attorney at the DFPS Appellate Unit, and Mark Zuniga, Staff Attorney for the Texas Justice Court Training Center. A PDF copy of the PowerPoint presentation, along with a supplemental paper written by Ms. Capace and Mr. Zuniga, are available for download on the Children's Commission On-Demand Training and MCLE webpage. A direct link to this page was included in your reminder email that you received prior to this presentation. For those watching live, a Q&A feature will be available during the webinar, and questions will be addressed at the end of the presentation if time allows. For those watching this live, the MCLE number will be provided at the end of today's presentation. It is now my pleasure to turn things over to our co-presenters, Mr. Mark Zuniga and Ms. Leslie Capace.
Thank you very much. I will be going next. And let me say that one of the advantages of being able to make this presentation is that I've gotten an opportunity to work again with my old coworker Leslie, and it's been an absolute pleasure, and I've really enjoyed it. So thank you for that. And so what we're going to talk about here is, okay, so you have the trial, and you're in front of a district court judge or a county court of law judge, but you need to worry about the appeal as well. And if there are issues on appeal, how do you make sure you've done everything you need to at the trial level so that you can argue those issues on appeal if you need to? And so that's where we're going. And we're specifically trying to aim this towards a child welfare law perspective. So let me see if I can do this. Okay, so let's talk about preservation generally before we get to the specifics. So we've got the rule of appellate procedure, and it says, look, if you want to complain about something on appeal, you have to timely make a request or an objection or a motion, and it has to state the grounds for the ruling with sufficient specificity so that the court is actually aware of the complaint. And then the rule also says, unless the specific grounds were apparent from the context. I would be very leery to rely on that area of the rule because, of course, that's the appellate court bailing you out, which they may do or they may not. And then likewise, of course, you've got to comply with the rules of evidence, the rules of civil procedure, the rules of appellate procedure in order to preserve your rule. So you've got to make that motion or that request or that objection, and then you've got to get it ruled on. Sometimes a judge is going to think they acted in a way that made it obvious what the rule was. And sometimes they're just going to forget to have done it. It'll seem obvious. You need it on the record. Or if the court is refusing to rule, which I find, I don't know that I've ever seen that. I think nor if I go, Judge, I'm sorry, I'm just trying to preserve my record. I need a ruling. They normally give it to you. But if you specifically objected to the lack of a ruling and they still refuse, then you have preserved what you need to on appeal. Now, doing an objection, the rule is it's got to be made at the earliest possible opportunity. And it must be specific, by which I mean you can't just sit there and list every rule of evidence for any objection just to see what later comes out and what has to happen. That's not going to work. It's got to be a specific issue, and that issue is the only issue that is preserved on appeal. Likewise, if one parent makes an objection, that does not preserve the error for the other parent. Likewise, if the ad litem makes an objection, the department has not preserved appeal if they want to go forward, unless they also make the objection as well. So something to keep in mind. Now, there are exceptions to the preservation requirement. One, of course, is when the record shows on its face that the court rendering the judgment lacked subject matter jurisdiction. And under that scenario, you don't have to make an objection. Now, in criminal cases, there's something called, there are certain instances where you do not have to preserve error. For juvenile delinquency cases, those are technically civil, but from an appellate standpoint, that preservation rule is still the same. And so potentially in a juvenile case, you can get away with not preserving your error under certain circumstances, and it changes things up, but there you go. Third point, The error has to directly and adversely affect the interest of the public generally, as that interest is declared by a Texas statute or the Texas Constitution. I would not rely on that as an exception, and I'll discuss some of that later. That's the appellate court bailing you out, which they may or they may not do. I wouldn't trust it. But also, another way that error does not have to be preserved is if the appellant was denied the right to counsel, which makes sense. If a mother doesn't have an attorney, then the mother doesn't know that she has to object. And so they're saying you don't have to do that. You do not have to preserve error in that circumstance. Now, with regard to that third point, right? That's interest of the public generally. Well, the right to parent is an interest generally that's been reflected in our Constitution. It's reflected in our statutes. And yet the Supreme Court of the state of Texas has made it very clear that because the legislature intends for these cases to have finality and to be expedited, then you still have to preserve errors. You can't sit there and expect, again, the appellate court to save you. They're going to expect you to make an objection, and if you don't, then you're going to be left hanging. So we're going to talk now about specific issues in terms of preserving error. Let's talk about it at the voir dire section. So imagine a scenario where you start talking to the veneer panel, and you start going to a particular subject, and the judge goes, "Oh, no, you're not going to go there. We're not going to let you go there." At that point, you've not preserved error. If in fact you thought that it was in fact an appropriate area for you to ask questions in. So the subject isn't enough. So you have to go on the record, maybe not necessarily in presence of the jury, but you have to go on the record and specifically state the specific and proper questions you want to ask, and then why you think those questions are important and valid. And then you have to get an adverse ruling. So in that particular instance, if that's what you want to complain about, that's what you have to do. These error preservation issues at voir dire are perhaps the trickiest. And this is one of those reasons why. Now let's talk about another issue. And again, this is, I would never worry about or I would never handle a challenge for cause and preservation of error without going to my paper or without going to a book or without having some reference, because I'm worried that's not going to. But here, let's say you wanted someone challenged for cause and the judge denies it. You want to challenge that on appeal. In order for that to happen, you have to have used a peremptory strike on that particular objectionable person. You then have to have used all of your remaining peremptory challenges. Then you have to note to the court, judge, there's this other person who's getting on this panel. And had you struck in the other person for cause, I would have been able to have a peremptory challenge to keep that person off. But because you didn't do that, I'm stuck with this person on my jury. Those are the steps you have to take. If you want to complain on appeal that the court should have struck in a veneer member for cause. It's much easier on the reverse side. If the court granted a challenge for cause and you think that's erroneous, all you need to do is object to that in order to get it. Okay, so let's talk about specific issues involving evidence. So let's say there's evidence that you do not want admitted. You're trying to fight its admission. You have to object. And so your objection has to be appropriate and timely, and it must happen each and every time a piece of evidence is introduced. So if a drug test is inadmissible, you have to complain about it every time it is discussed, which is annoying to everybody. Juries aren't happy with that, but that's what you have to do in order to preserve your error. Okay. And then if you objected to a question and your objection was sustained, but you still have concerns about it, you must ask that the response, if one was given, be struck from the record. And then this last point is one I have seen and I think is concerning. Let's say there's a drug test. You don't think the department did enough to authenticate it and should not be admissible. Well, that gives you a difficult issue, because what if there are problems with the test itself? And so if you ask about the test, then you are allowing evidence about the test to come in without objection. and then arguably you have now waived admissibility of it. So that's, again, something to keep in mind and be worried about. Now let's talk about preserving a claim that evidence was erroneously admitted at pretrial. So you're kind of tired of, you don't want the jury to hate you by standing up and objecting all the time. So you can file a pretrial motion to exclude. And if you do that, you have preserved error and you don't have to be jumping up all the time. So that's good. That is not a motion to eliminate. Remember, a motion to eliminate says, Judge, don't let them talk about this without approaching you first outside the presence of the jury. That's not an evidentiary ruling. And so that does not preserve error. But here's where things get difficult. Sometimes an appellate court is going to say, yeah, you called it a motion in limine, but in fact, it wasn't a motion in limine. It was a motion to exclude, and therefore error was preserved. Now, here's an example of that out of Texarkana. So it was called a motion in limine, but the motion specifically asked for a court order that prevented the department and the ad litem from calling any witness who had not been properly disclosed in discovery. And so they said, well, that's not a motion in limine. You're asking the evidence be excluded, and therefore it is a motion to exclude, and therefore you preserved error. And so I think that that both sides did not optimize what they should have done in this case. What the attorney for the parent should have done, in my opinion, is they should have said, they should have called the motion a motion to exclude, and therefore been crystal clear, and they don't have to worry about Texarkana feeling sorry for you and letting you get away with it. And so that's what they should have done, or they should have objected each and every time someone else came in. The department also didn't act in best practices here because, of course, you're being vague. The department, the motion is exclude all these people who were not properly disclosed in discovery. And so what the attorney for the department should have done is say, Judge, I want you to know this witness I'm about to call, they in fact were properly disclosed in discovery. Next witness, Your Honor, I want you to know this next witness was not disclosed in discovery, but it's not an unfair surprise, and that's why it's not an unfair surprise. Now, you run the risk as an attorney for the department by having witnesses excluded, and you yourself did the exclusion. But the advantage is you've preserved your record, so that when the parent's attorney takes this on appeal, you can sit there and say, yes, they weren't properly disclosed, but the evidence was still admissible because it wasn't unfair surprise. Let's talk about writing objections. This is also an example of something you can do so that you're not annoying the jury and the judge by objecting all the time. And this is, of course, within the discretion of the judge. They can allow you to make an objection. It saves time, but it allows you to preserve issues on the appellate record. I've known a judge to say, I'll grant you a writing objection for as good as it'll do you, because it doesn't always work. It can promote an orderly trial, but you have to be specific and unambiguous. So if you're doing a writing objection, you have to identify the source of the objectionable testimony, the subject matter of the witness's testimony, and the ways in which that testimony would be brought before the jury. I'm going to give you an example of a case. This is ADK. I represented the department in this case. And again, we're in Texarkana for some weird reason. So in this case, you had two witnesses testifying, the caseworker and the CASA volunteer. They both said very similar things. They both said that the children told them that the father made them fight each other for his entertainment. And so that is potentially a statement about abuse. And then they also both testified that the children told them that they loved placement and wanted to be adopted there. And the objection was made by the father when the caseworker testified that the children said the father made them fight. So on appeal, father said, I had this vague objection. It covered all hearsay testimony by all children as testified to by both the caseworker and the CASA volunteer. I was representing the department. My argument was it was all hearsay statements, but only those made by the caseworker. And that would be both the statements about future intent by the children and also the statements of abuse. The Court of Appeals went a different route. All three of these routes, by the way, are potentially reasonable. They said, well, it's all the running objection applied to all statements from both the caseworker and the CASA volunteer with regard to possible abuse. It did not apply to whether or not the children loved placement and wanted to be adopted. And so, by the way, the appellate issue was, in fact, the statements that the children loved placement and wanted to be adopted. So, at that point, the Court of Appeals did not bail out the parent's attorney. And so, this is one of those reasons why you want to make sure your objection is, in fact, specific. Personally, I would make it specific to the witness and to the specific type of testimony and the particular subject matter so that it is clear when you need to object again. Now, let's talk about instances where you want the evidence admitted and the court is saying it doesn't get in. How do you preserve that? One option is an offer of proof. So the rule says it has to be done as soon as practicable. In my experience, the best way to do that would be immediately after the evidence is excluded. Why? Because that way you don't forget. Trials are stressful, a lot's going on. The one thing you don't want to do is in the middle of closing arguments realize that you didn't make your offer of proof. And so if you look here, the deadline is before the charge is read to the jury. So I have seen it where an offer of proof was made after the charge conference, but before the jury came in for the charge to be read to them. I'm not a fan of that because that prevents or makes it unlikely that the court is going to change their mind because you're kind of stuck where you are. But that is where the deadline is. And by the way, Leslie is going to be talking here in a few minutes about a bill of exception. I would note here the deadline here is before the charge is read to the jury. So potentially an offer of proof might not be available, but another option will be. But let's still talk about offer of proof. Two different ways it can be done. You as the attorney can say, Your Honor, I would have called this witness. This is what their testimony would have been. This is why it's relevant. And you can say that it can be short. It has to be just enough so that the court knows what is being excluded and potentially whether or not that excluded evidence is harmful. And so that can be done. However, and there are advantages and disadvantages to do that. One, of course, it's short and to the point. Let's move on. We've got a lot of things going on. You can make sure that you actually get the testimony in that you want and you avoid what you don't want. So imagine a witness who has some great things to say to you, but if they were allowed to be on cross, it would also be bad. That could also potentially be part of the offer of proof. This way you avoid that issue. And you make sure that this way your evidence has exactly what you need and it is sufficient. The disadvantage, of course, is potentially this could be something that the client wanted to say in open court. And even if they can't say it in front of the jury, they at least have the opportunity to say it. And so you're potentially depriving of them that if you go this route. Additionally, you're still hoping at this point to talk the judge out of it and letting them change their mind. Potentially an emotional witness can be, based on the situation, might be more valid in making that happen. Now, of course, the rule says must, as in at the party's request, the court must direct that an offer of proof be made in question and answer form. So that's what I'm talking about. You have the witness up there, you're asking the question, they're answering it. This is outside the presence of the jury. This is just done as an offer of proof. The court must do that. However, it's not reversible error to deny that request if the appellant is allowed to make an offer of proof through the attorney or the appellant was denied the opportunity for a bill of exception, and Leslie's going to be talking about the bill of exception. In this case, we're talking EJ. The evidence was excluded because mother's attorney was given a set amount of time in which to present her case. She ran out of time before she could make her case in chief. And so she wanted to bring those witnesses in anyway and do a Q&A. And remember, we're already running up against time limits. And so the judge said, no, you can't do that. So even though the rule says must, and the court didn't, there was no remedy because the attorney could have made an offer of proof through herself, or could have done a bill of exception. Those things were not denied to her. So therefore, it was not reversible error. And so now we're going to talk about formal bills of exceptions, and I hand it off to you, Leslie.
Thanks, Mark. This presentation has felt like a flashback to the fun days when we were both with Appellate. Hi, everyone. That brings us to formal bills of exception. So described in Rule 32 of the Texas Rules of Appellate Procedure, the purpose of a bill of exceptions is to allow a party to make a record for appellate review of matters that would not otherwise appear in the record. It's most often used for complaints about the trial court's erroneous exclusion of evidence that, because it was not admitted, would not otherwise be part of the appellate record. But it's not used often, and particularly not in our cases. The bill does not require a particular form of words, but the objection must be stated with sufficient specificity to make the trial court aware of the complaint. When the complaining party presents the bill of exception to the trial court, if the parties agree on its contents, the trial judge simply signs the bill and files it with the clerk. If the parties do not agree, the judge will hold a hearing. After this hearing, the judge may sign and file the bill of exception, suggest corrections, and then sign and file that corrected version. Or if the complaining party refuses the corrections, prepare, sign, and file a bill that accurately reflects what occurred in the trial court. So this is an example of a bill of review. This is actually the only bill of review that has been an issue in an appeal that came through DFPS appellate, at least in recent years. This was actually Mark's case. He represented the department in this case when he was part of the unit. In a civil case, a formal bill of exception must be filed no later than 30 days after a party files their notice of appeal, but an appellate court may grant a 15-day extension if an appropriate motion is filed. When the appellate record contains the evidence needed to explain a bill of exception, the bill itself does not need to repeat it, and a party can simply attach a transcript of the record containing the evidence. Keep in mind, though, that filing a bill of exception does not excuse the requirement to timely raise issues before the trial court. So the bill of exception included in the PowerPoint a few slides ago that we looked at was from this case, in Ray KO out of Texarkana. In KO, an incarcerated mother used a bill of exception and its supporting memorandum, both filed after her motion for new trial was denied, to assert for the first time that her due process rights were violated when the trial court tried the case and heard the motion for new trial in her absence. The trial court held a hearing on her bill of exception. At the hearing, the court noted these issues were novel, that mother's attorney had not made a request for a bench warrant, nor had counsel asked to secure his client's presence by phone. The trial court, though, nevertheless found and approved the bill of exception, which stated, among other things, that mother was incarcerated at the time of trial and her attorney was unaware she had been moved to another prison facility shortly before the trial in order to give birth. But on appeal, the Court of Appeals still held that because mother waited until after the notice of appeal was filed to raise novel issues in her bill of exception, she failed to preserve her due process complaints for appellate review. So in short, a bill of exception will only be effective if the issue was preserved in the trial court. Okay, that brings us to preserving legal and factual sufficiency challenges and jury trials. So most appeals from parental termination cases involve a challenge to the legal and/or factual sufficiency of the evidence in at least one or more of the issues raised in the appeal. Sufficiency challenges arising from bench trials do not have to be preserved. However, there are strict preservation requirements governing jury trials. If these requirements are not met, the sufficiency challenge is deemed to be waived on appeal. So in order to preserve a legal sufficiency challenge for appeal, a party must file a motion for instructed verdict, object to the submission of a jury question, file a motion for judgment notwithstanding the verdict, move to disregard the jury's answer to a vital fact question, or file a timely motion for new trial. To preserve a factual sufficiency challenge, a timely motion for new trial must be filed. Therefore, a motion for new trial will preserve both legal and factual sufficiency, and that's what we see most often done in our cases. One thing to note is that a motion for new trial filed by one parent does not preserve sufficiency review for the other parent. Each parent must file their own motion or file a joint motion. So here is an example of a motion for new trial. And, I just want to mention here that the examples included in the PowerPoint are not, necessarily the perfect way to do something, but they were sufficient to preserve error in these cases. Of note, this motion for new trial also challenges the sufficiency of the evidence supporting the reasonable efforts to return the child finding, a finding that we have just recently began to see frequently. Parental termination orders resulting from a DFPS suit filed on or after September 1st, 2023 must include a finding that the department made reasonable efforts to return the child to the parent, and despite those efforts, a continuing danger remains in the home, or find that reasonable efforts were waived by an aggravated circumstances finding under Family Code Section 262-2015. And that is under Texas Family Code Section 161001F. It has been just over 1 year since this provision became effective, so we are now seeing this issue come up more on appeal. Section 161001F states the court may not order the termination of parental rights unless the court finds by clear and convincing evidence and describes in writing with specificity in a separate section of the order this reasonable efforts finding. But whether reasonable efforts were made is a fact question that is submitted to the fact finder, so the jury in a jury trial. As with grounds in best interest, the trial court then encompasses this finding in its order in accordance with the jury verdict. So therefore, preservation of a challenge to the sufficiency of the evidence supporting a reasonable efforts finding is required in the context of a jury trial. In MS, the Texas Supreme Court held the failure to preserve a meritorious factual sufficiency complaint in a parental termination case may constitute ineffective assistance of counsel. There in MS, the court remanded the case to the Court of Appeals to determine whether counsel's failure to preserve the factual sufficiency issue was not objectively reasonable and whether this error deprived the mother of a fair trial. So, this is something to keep in mind as counsel for a parent. A motion for new trial should be filed anytime there's a possibility that sufficiency may be challenged on appeal. So, should the appellee raise the issue of preservation? And the answer is yes. When there is a sufficiency challenge, the appellee, usually the department, should always raise the issue of preservation in its responsive brief when the appellant failed to preserve error from a jury trial. In the context of an appeal from a jury trial in a parental termination case, the Dallas court noted it is unclear from existing case law whether an appellate court must, should, or may raise the issue of preservation on its own. And if you take a look at the cases, you'll notice that many opinions that overrule sufficiency challenges based on the failure to preserve do not mention whether the appellee raised the issue of preservation or if the appellate court did so on its own. So, it's really important to raise it to ensure that the court addresses it. Okay, that brings us to jury trials in subsections D and E. In NG, the Texas Supreme Court held that due process requires a heightened standard of review of a trial court's finding under endangerment grounds D and E, even when another ground is sufficient to uphold the judgment because of the potential consequences to another child under subsection M. The court further decided that due process and due course of law requirements mandate that an appellate court detail its analysis for an appeal under subsections D and E. In BS versus the department, the Austin court examined NG's holding in the context of an appeal from a jury trial in which neither parent preserved their sufficiency challenges, which included endangerment grounds. Relying on NG, the father argued that they were not required to preserve so long as a parent, quote, presented the issue, end quote, to the Court of Appeals by raising it in their briefing. He contended that to allow these endangerment grounds to remain unchallenged would violate their due process rights. But the court disagreed, explaining father overreads NG, which requires such a review when the parents have presented the issue on appeal and did not involve parents like these who had failed to preserve their challenge. The court explained that at most, the ruling in NG presupposes that the appellant has preserved the issues for appeal. Accordingly, the court declined to accept sufficiency challenges in termination cases decided by a jury from the longstanding requirement of error preservation. Before other appellate courts to have considered this issue reached the same conclusion, D and E are not accepted from jury trial preservation requirements. Okay, that brings us to notable challenges requiring preservation. The first is Texas Family Code Section 161.001D, which provides a possible defense for parents who fail to comply with provisions of a court order under subsection O. Under subsection D, parents must establish by a preponderance of the evidence that they were unable to comply, that they made a good faith effort to comply, and that their failure to comply was not attributable to any fault on the part of the parent. The big question, does it have to be pled? Texas Rule of Civil Procedure 94 provides a party shall affirmatively plead any matter constituting an avoidance or affirmative defense. At least 2 courts of appeals have concluded that Section 161.001D is an affirmative defense that is waived if not pled or otherwise raised in the trial court. And those 2 courts are the Houston 14th and Tyler. No appellate courts have decided that Section 161.001D does not have to be pled. Courts have generally taken the position that, even if we assume without deciding that the parent did not waive their 161.001 defense for failure to specifically plead it, we conclude that the parent failed to meet the parent's burden of proof to establish it, and they sort of handle it that way. As far as best practice, though, a parent's attorney should always plead subsection D if predicate ground O is sought by the department. Okay, so here is a answer that was filed in one of the cases at the trial court level, one of the cases that we handled on appeal. In addition to a general denial, this answer also pled 161.001D. But keep in mind that simply pleading a subsection D defense is not enough. The parent has the burden at trial to prove the elements of the 161.001D defense. In JG versus the department, although mother raised 161.001D and asserted she had a disability, the Court of Appeals concluded that mother did not meet her burden of proof on her subsection D defense. Mother testified that complying with the required drug testing was, quote, harsh on her mental and on her physical, that the visitations were breaking her down, and that she had asked to change visits from the office setting because it was detrimental, heartbreaking and really depressing to her. But the Court of Appeals explained that descriptions of mothers' attempts to comply with specific provisions are not evidence of an inability to comply with the orders, whether that inability is allegedly due to her disability or to another reason. At most, the court said this evidence might explain why mothers stopped taking drug and alcohol tests and attending visitations after January 2021, but that subsection D requires more than an explanation. It requires proving an inability to comply and that such failure was not due to any fault of the parent. The court went on to explain that although there was some evidence that mother suffers from depression and seizures and has a low IQ and other unspecified mental health issues, such evidence did not establish her inability to comply. Okay, this brings us to the trial court's findings under Texas Family Code Section 263-401B, which essentially provides that if the trial court has not commenced, the court may only extend the dismissal deadline if extraordinary circumstances necessitate the child remaining in the department's temporary managing conservatorship and that remaining in the department's conservatorship is in the child's best interest. In GXH, the Texas Supreme Court concluded that while a trial court's failure to timely extend the automatic dismissal date before that date passes, through a docket sheet notation or otherwise, is jurisdictional, plain defects relating to the other requirements of 263-401B are not. In JS, the trial court rendered an order on the record extending the dismissal date and found the extension was in the child's best interest, but failed to make express findings regarding extraordinary circumstances, but no party objected. The trial court entered a written extension order containing both 263-401B findings several weeks after the dismissal deadline passed. On appeal, the Court of Appeals sua sponte determined that the trial court erred by failing to make the extraordinary circumstances finding and held that therefore the final judgment was void. The department filed a petition for review with the Texas Supreme Court, arguing in part that while failure to enter an extension order on or before the dismissal deadline deprives a court of subject matter jurisdiction, the findings required by Section 263-401B do not implicate the trial court's subject matter jurisdiction. The Texas Supreme Court agreed with the department. Because the statute does not use any language referencing jurisdiction in subsection B, the court reasoned that this subsection should not be construed as jurisdictional, and therefore such challenges must be made in accordance with the usual error preservation rules. Specifically, the court concluded because mother did not object to the trial court's failure to comply with the non-jurisdictional findings requirement prior to the initial automatic dismissal deadline, that error cannot be addressed for the first time on appeal. So JS basically made the 263-401B findings a non-issue for appeal because a timely objection, one made prior to the initial automatic dismissal deadline, is generally going to prompt the trial court to then make the requisite 263-401B findings. But, an objection should still be made to preserve error regardless. Failure to do so could form the basis for an ineffective assistance claim. Okay, and that brings us to our last topic, judicial notice. So this, sort of a simple question, what time the sun set on a particular date in Houston. It uses this to illustrate the right and wrong way to ask the court to take judicial notice. But this example can be applied to any situation. Note the wrong way omits the fact that the attorney is asking to be judicially noticed. Okay, any error in taking judicial notice generally must be preserved in the trial court to raise the issue on appeal. Per Rule of Evidence 201, a judicially noticed fact must be one not subject to reasonable dispute because it is either one, generally known, or two, capable of accurate and ready determination by sources whose accuracy cannot be reasonably questioned. There's also specific provision in Rule 201 that grants parties an opportunity to be heard on the propriety of taking judicial notice. So therefore, when evidence concerns disputed facts and opinions, it should not be judicially noticed. A trial court may take judicial notice of its own records in matters that are generally known, easily proven, and not reasonably disputed. Further, an appellate court may presume that the trial court took judicial notice of its own record, even without a request or an announcement that it is doing so. In a sufficiency review, however, appellate courts are only permitted to consider factual statements or allegations that were admitted during the final hearing. In EF, the trial court took judicial notice of pleadings, service of process documents, orders, service plans, and CASA reports at the termination trial. However, on appeal, the Court of Appeals noted that a court may, for example, take judicial notice that a pleading has been filed, of its own orders, or that it signed an order adopting a service plan and the plan's requirements. But a court may not take judicial notice of allegations contained in such documents, and the allegations cannot be used to support a termination order. Therefore, the court expressly did not consider the allegations in the documents the trial court judicially noticed in its sufficiency review. Further, a trial judge cannot take judicial notice of testimony even in a retrial of the same case, such as the trial before the associate judge at a de novo hearing. In CG, in a single issue on appeal, Mother asserted that the district court erroneously took judicial notice of the trial before the associate judge without formally admitting into evidence a recording or transcript of that trial, resulting in insufficient evidence to support the termination. In this case, the district court informed the parties at the beginning of the de novo hearing that it was taking judicial notice of, quote, all of the contents of the trial before the associate judge, including all questions and all answers. Mother failed to object to this procedure at any point during the de novo hearing. So accordingly, the Court of Appeals on appeal decided any error in the district court's taking of judicial notice had been waived. So, this case emphasizes the importance of objecting to improper judicial notice to preserve that error for appeal. Okay, so now turning to another opinion. In JB, the trial court took judicial notice of the testimony from another case at the request of the department. Appellant's counsel indicated he had no objection. No reporter's record or transcript of the testimony from the other case was offered into evidence as an exhibit in the case or otherwise made a part of the reporter's record. Appellant's parental rights were terminated pursuant to subsections D and E. In her first issue on appeal, appellant argued that the trial court abused its discretion when it terminated her parental rights based on evidence that was not properly before the trial court. The Court of Appeals agreed that she failed to preserve her issue with respect to the trial court's ruling on the admission of the testimony. However, the court sustained appellant's issue to the extent that it related to the termination of her rights based upon evidence that was not admitted. In appellant's second and third issues, she challenged the sufficiency of the evidence supporting the trial court's D&E findings and its best interest finding. The Court of Appeals noted that during a sufficiency review on appeal, it was not permitted to consider factual statements or allegations that were not admitted during a final hearing. Therefore, the court reviewed only the evidence and testimony presented during the final hearing and contained in the reporter's record in its sufficiency analysis. The Court of Appeals reversed after finding the evidence factually insufficient to support the trial court's best interest finding. So even though the appellant waived the improper judicial notice issue, the department's inappropriate request preserved nothing for the sufficiency review. So the difference in these two cases, in that the first case, CG, did not include a sufficiency challenge. Because the error in taking judicial notice was not preserved, that was her sole issue, that disposed of the appeal. So it's important to keep in mind that improper judicial notice does not preserve anything for sufficiency review, regardless of an objection. And that brings us to the end of our presentation. Thank you.
Thank you so much, Leslie and Mark. We do have a question right now that does state, what can you do to preserve your record for appeal when a judge does not want to rule on your objection?
Well, under, that's 33.1, is it not? You have to specifically object to the fact that the judge has not made a ruling. And then after that, still refusal, you've preserved error. That's what the rule says.
Mm-hmm.
And in my experience, if you gently go, Judge, I'm sorry, I'm just trying to preserve error, you're normally okay.
Leslie, do you have anything to add on that?
I agree with Mark. That's the best course.
All right. One other question, Leslie, that has come in is on judicial notice. A lot of, there have been some other trainings where individuals have been told not to ask for judicial notice. So when would be a good time to actually ask a court to take judicial notice, and what things should they be asking about the court to take judicial notice on?
So, again, the trial court can take judicial notice that pleadings were filed, orders that are in the court's file. It's those factual allegations, things that are contained in court reports filed by the department. Those are the things that the court cannot judicially notice. So even if the court does judicially notice those sort of factual allegations and things like that, those things are not going to be considered in any sort of sufficiency review on appeal. So again, the things that are appropriate for judicial notice are just those orders, pleadings. Those are the things that are contained in the court's file.
I certainly think you want to be very careful where there are salacious allegations that are in the file, like they're in an affidavit, they're in a CASA report. So you, as an attorney for the department, you don't want to take judicial notice and think, okay, I've got dad's arrest for sexual assault in there. No, you don't.
Mark, you mentioned that when you have an objection sustained, that you should ask to have the record struck or the answer struck. What is the effect of not doing so?
Well, you run the risk of the jury not realizing that evidence is inadmissible. And then likewise, let's say if it's something that just so there's your risk. The first time I did a jury trial, I was sitting next to my client's mother, and all of our objections were getting by my boss, he was making, they were all being sustained. And the client's mother whispers in my ear, "Why does this judge hate us?" And so we kind of forget that the court doesn't always, that the jurors don't realize exactly everything that's happening. And it sends a very clear message to the court or to the jury that that's the message they're not supposed to include. It also prevents any possibility of the appellate court using the evidence anyway, saying, well, you waived it.
I agree with Mark. If it's not struck, you run the risk that it will be considered.
All right, well, now then we have two more questions that have come in. The first is, what about judicial notice of a court of continuing jurisdiction inquiry and/or paternity registry? If there is a hearsay objection to their content, how do we fight it?
I think those are things, I mean, I would say that those are things that would probably, if they're going to be an issue, those are things that would probably be better admitted than to ask the court to take judicial notice.
I know, I would say 90% of the time, I admitted the CCJ search as an exhibit. I don't know that most attorneys do it. I did it as a way of making sure that I knew I did it and that the judge knew that I actually did the search, I actually looked for it, and I did it. It's the issue there is actually reversed. So let's say, for example, the CCJ search. That only matters if, in fact, there is a court of continuing jurisdiction. So if, in fact, there is, in fact, a court of continuing exclusive jurisdiction, but the search came back saying there's nothing. All the department has to do, and this is an important requirement, it has to have it in the file. It doesn't have to present it as evidence. It has to be filed, and it has to be filed at the time of rendition. So if what the department wants to do is say, Judge, you do not have a continuing exclusive jurisdiction problem, then you have to have it filed. It does not have to come in through judicial notice. It does not have to be evidence at trial. It is merely something that the appellate court will look later at if for some reason it becomes an issue. Now let's turn the reverse. You represent the parent, and you know for a fact that there is a court of continuing exclusive jurisdiction. The case law is somewhat divided in this point. Certainly, Texarkana, for example, would say jurisdiction is jurisdiction. You don't have jurisdiction, therefore you don't have to preserve error. The court had no jurisdiction. The judgment is void. The Austin Court of Appeals, at least the last time I checked, and Leslie would be more on top of this than I would. The Austin Court of Appeals says no, because the jurisdictional issue is not on its face. So it's not invalid on its face. It requires an objection. So, for example, this is the case I'm thinking out of the Austin Court of Appeals. You had Travis County as the court of continuing exclusive jurisdiction. The parental termination case happened out of Williamson County. They did a CCJ search. The CCJ search was not filed. Therefore, because it wasn't filed, you don't have that safe harbor. However, the parent's attorney didn't object to the rendition of the order, and so therefore the Austin Court of Appeals held you've not preserved error in that instance. And that only deals with CCJ, not with parental registry, but there you go.
I think I would be more to follow that Texarkana court and err on the side of caution. And jurisdiction is jurisdiction. If you don't have it, I'm afraid the court would find that the order is void.
Well, I certainly agree that best interest would be file the search. Absolutely file it. And so you need to, if you're representing the department, you need to presume that that the parent's attorney does not have to preserve error. But if you're the parent's attorney, you need to presume the opposite, that you have to make the objection.
Agreed.
What pointers would you all provide to preserve error for an attorney with an unknown or non-responsive parent?
Well, what error are you trying to preserve? I mean, this puts a parent's attorney in a difficult position, because if you sit there and say, Judge, I can't find my client, this is everything I've tried to do. On the one hand, you are preserving potentially your reputation, and you're preserving any future claim for ineffective assistance of counsel. but you're also telling the fact finder that your client doesn't care enough to stay with you. So I would need to know what specific issue. I, as when I was a parent's attorney, I have said to the court, I can't find my client, and that got thrown back in my face. So I would be worried about it. But I don't know what specific issue they want preserved.
Well, the next question in the queue is, what can an appellate attorney do if the trial attorney does not file a motion for new trial? Often we do not get the chance to review the record until it is too late to do so.
And I assume that's in reference to preserving a sufficiency challenge from a jury trial. That is really tough. What I have seen some appellate attorneys do is, try to find legal issues and things that they can challenge instead. But that is very tough. It's always the hope that the appellate attorney will be appointed soon enough to where they can file that motion for new trial. But the trial attorney for the parent should be doing that.
Yeah, well, I think both the trial and the appellate attorney need to be concerned with that issue. And
Yes.
for example, let's say you get appointed. I would not wait for the appellate record. I would go immediately to the trial clerk and look for that motion for new trial if I still have time to file it.
Yes, agreed. Even if it's a phone call to the clerk's office, typically they're very helpful in terms of providing the information of what's been filed.
But usually when there's an Anders brief, a lot of times they'll say in the Anders brief is there wasn't a motion for new trial filed, so I can't argue it. But then, if you're doing an Anders brief, you even go further and go, and there's no ineffective assistance because the evidence is still insufficient. But so that's a potential way to get back in, is to say, well, it was ineffective for the trial attorney not to file a motion for new trial, but ineffective assistance almost never wins. So that's a hard road to hoe if you have to do it.
Okay. I think that's a great stopping point at this time. On behalf of the Children's Commission, I would like to thank our panelists, Mark and Leslie, for that very informative presentation. We encourage our readers to email any questions submitted through the Q&A feature that had not been responded to live today directly to Leslie and Mark, and their email addresses are available on screen. And thank you for viewing today's presentation. State Bar has approved this course for 1 hour of MCLE credit with 0.25 of ethics. And the course has also been approved by the Texas Board of Legal Specialization for 1 hour of certification and recertification credit for attorneys and paralegals in the specialty area of child welfare law. Individuals who are watching this replay will be able to contact cc.training@txcourts.gov for MCLE self-report information. As a reminder, you may access the replay of this and all of the other Commission's MCLE webinars for free on our on-demand training and MCLE webpage. Once again, thank you for joining us and have a wonderful rest of your day.